All right, get ready to dive into some really interesting legal stuff. You've given us this stack of documents about contracts, but it's not just any contract law, right? It's Dutch and Surinamese contract law with a special focus on this thing called good faith.
And it really gets fascinating when you see how this good faith idea actually plays out in real life. We're not just talking theory here,
Yeah, I mean, we've got excerpts from a Dutch law textbook,
which lays the groundwork, the basic principles.
but then we've also got all these real-life court cases.
Exactly. So we can see how judges are interpreting these principles. And I think that's where it gets really exciting.
Okay, so before we jump into all that, can you give us a quick overview of what makes these legal systems tick? I know they're both rooted in this concept of, what is it? Vermogensrecht.
Vermogensrecht. Yeah, that's a mouthful, isn't it?
It is. Can you break it down for us? What does it actually mean?
Think of it as the big umbrella that covers anything that affects someone's assets and liabilities. So basically, it's about your stuff, what you own, what you owe, and all the rights and obligations that come with that.
Okay, so it's like the whole financial framework for how people interact with each other, legally speaking.
Exactly. And contracts are a big part of that framework.
Got it. And I see Suriname is actually in the process of updating its whole legal system, right? They're modeling their new civil code after the Dutch one.
That's right. They're working on aligning their laws more closely.
And within that new code, are there specific sections that deal with contracts?
Absolutely. Books 3, 6, and 7 are the key ones to watch for contracts.
Okay, can you give us a quick rundown of what each of those books covers?
Sure. Book 3 lays out the general rules for dealing with assets and liabilities. It's kind of the foundation for everything else.
Got it, the basics. So what about book 6?
Book 6 dives into the nuts and bolts of contracts, what makes a contract valid, what happens when things go wrong, all that good stuff.
Okay, so it's like contract law 101.
You could say that. And then Book 7 gets into the specifics for different types of contracts. So, sale agreements, leases, loans, that kind of thing.
So they break it down by category.
Exactly.
That's super helpful context. So now let's get to the heart of it all, this good faith principle. From what I've seen, it seems like a pretty big deal in both Dutch and Surinamese law.
It's huge. It's not just a minor detail. Good faith is like this underlying principle that influences how contracts are interpreted, how they're supposed to be performed, and even what kinds of agreements are considered acceptable in the first place.
So it's not just about ticking boxes and making sure all the legal terms are in order.
No, it goes way beyond that. It's about ensuring that agreements are fair and reasonable. And that takes into account the intentions of both sides, not just what's written in black and white.
So are you saying that sometimes good faith can actually override what's written in a contract? Like even if both parties signed it, a judge could say, "Nope, that clause goes against the spirit of good faith, so we're not enforcing it."
That's exactly what I'm saying. And that's what makes it so interesting, right? It adds this whole layer of complexity and nuance to contract law.
Okay, I'm already starting to see how this could get complicated. But before we dive into the specifics, I think we need to unpack the different interpretations of good faith because I'm getting a sense that it's not a one-size-fits-all concept.
You're right. There are actually two main ways to think about good faith, and both of them play a role in Dutch and Surinamese law.
Okay, I'm all ears. Hit me with those nuances.
So on one hand, you have what's called the subjective interpretation of good faith.
Subjective, meaning it's all about what the individual actually knew or believed at the time.
Exactly. So with this interpretation, the focus is on whether someone genuinely didn't know they were doing something wrong. It's like, hey, I had no idea that was against the rules or that it would harm the other party.
Got it. So it's like making an honest mistake, basically.
Pretty much. It's about acting with a clear conscience, even if the outcome might not have been ideal.
Okay, that makes sense. But you said there was another interpretation, right?
Right. And this one's a bit trickier. It's called the objective interpretation of good faith. And with this one, it's less about what you personally knew and more about what a reasonable person in that situation should have known.
Oh, so even if you think you're acting in good faith, the judge might say, come on, any reasonable person would have known that wasn't okay.
Exactly. So even if you didn't have any bad intentions, you could still be held liable if your actions didn't meet that objective standard of reasonableness.
Okay, so it's like there's this baseline of what's considered acceptable behavior, regardless of your personal knowledge or intent.
Exactly. And that distinction is super important because it really affects how these cases are decided. It's not just about what you knew, it's about what you should have known.
Wow, this is already getting my brain working. It's not just about the letter of the law, it's about this whole other layer of ethics and reasonable expectations.
And that's what makes it so fascinating.
So now I'm really curious to see how all of this plays out in those real-life cases you mentioned. What's our first legal puzzle?
Let's start with a classic case from way back in 1926. It's called the Gutsche Baumeister, which basically translates to the Gouda architect.
Okay, an architect from Gouda, I'm already intrigued. What did this architect get up to?
Well, this case is a great example of how Dutch and Surinamese law can use something called a natural obligation to hold someone accountable, even if there's no written contract involved.
Natural obligation. What does that even mean?
It's a bit of a tricky concept, but basically it means that even if you're not legally bound to do something, you might still have a moral obligation to do it.
Okay, so it's like your conscience telling you what's right, even if the law doesn't explicitly require it.
Exactly. And in some cases, that moral obligation can be so strong that it actually becomes legally binding. And that's what happened in this case.
Okay, so what exactly did this Gouda architect do? I'm dying to know.
Well, let's just say he wasn't exactly the most ethical guy. While he was overseeing this big construction project, he decided to line his own pockets by accepting some bribes.
Oh no, that's not good. Bribery's never a good look.
You got that right. And later on, he actually tried to argue that he wasn't legally obligated to repay those bribes.
Wait, seriously, so he was trying to get away with it just because there was no paper trail?
That was his argument. He was like, hey, there's no written contract saying I have to give this money back, so I'm keeping it.
Oh, that's sneaky. So what did the court say to that?
The court basically said, whoa, hold on a minute. Just because there's no formal agreement doesn't mean you can just keep money you got through illegal activities. They ruled that he had a moral obligation, a natural obligation, to return those bribes because accepting them in the first place was inherently wrong.
So the court basically said, dude, you know that was wrong, so you have to make it right, contract or no contract.
You got it. And that's what's so interesting about this case. It shows how good faith can be used to fill in the gaps, not just in a contract, but in the law itself. The court looked beyond the strict letter of the law and considered what was ethically sound.
Okay, that's a pretty powerful statement. One case in, and I'm already seeing how good faith isn't just some abstract concept. It has real-world implications. It's like a moral compass guiding the legal system.
It is. And that's what makes Dutch and Surinamese contract law so unique.
This is fascinating. I can't wait to hear what other legal adventures await us. All right, I'm ready for more. Give me another case. I want to see how this good faith idea plays out in different situations.
Okay, how about one that's a little more personal, a little more emotionally charged?
Ooh, bring on the drama.
It's a case from 1938, and it's sometimes called the 17-year marriage case.
Okay, that title already has me hooked. What happened?
Well, this case shows how good faith can sometimes act like a safety net, especially when the law itself might lead to a really unfair outcome.
I'm listening.
So picture this. A husband forces his wife to get a divorce after 17 years of marriage.
17 years. That's a long time.
It is. And then, get this, after the divorce, he tries to argue that he doesn't have to support her financially.
Wait, seriously? After all that time together, he just wants to walk away with no responsibility?
That's exactly what he tried to do. And technically, the divorce was legal.
So he was following the letter of the law, but...
But the court stepped in and said, hold on, that's just not right. They basically said that even though the law didn't require him to support her, he still had a moral obligation to do so.
So they invoked the good faith principle.
Exactly. They said that after 17 years of marriage, it's just not fair or reasonable to leave her high and dry, financially speaking.
So they took into account the whole context of their relationship, not just the legal technicalities of the divorce itself.
Right. They were looking at the bigger picture, the whole situation, and they ruled that his moral obligation to support his ex-wife was actually strong enough to create a legally enforceable debt.
Wow, so even though he might have thought he was in the clear, legally speaking, the court said, nope, you still have a responsibility here.
Exactly, and that's what's so powerful about this idea of good faith. It can sometimes create obligations that go beyond what's explicitly written in the law.
It's like this underlying principle of fairness that permeates the entire legal system.
Exactly. It's about making sure that the law is used to promote justice, not to enable someone to take advantage of another person.
Okay, these cases are really starting to paint a picture of how deeply embedded this concept is. It's not just a minor detail. It seems to be woven into the very fabric of these legal systems.
It really is, and that's what makes it so interesting to study. Okay, are you ready for another case?
Hit me with it. The more cases we discuss, the more I'm understanding how this all works in practice.
All right, let's fast forward a few decades and look at a case from 1981. It's often called the dragline case, but the actual name is Holloman de Klerk.
The dragline case, it sounds intense. What's a dragline anyway?
It's a huge piece of construction equipment, like a really big excavator.
Oh, okay, so we're talking heavy machinery. What happened?
So in this case, a transport company was hired to move this massive dragline.
I can imagine that would be a tricky job.
It was. And something went wrong during the move. There was an accident, and the transport company ended up suing their client for damages.
Okay, so far it sounds like a pretty standard business dispute. What's the good faith angle here?
Well, here's where it gets interesting. The transport company, Hallman, had all these standard contract clauses. You know, the kind that companies often use to try to limit their liability if something goes wrong?
Oh, yeah, those little snippets of legalese that no one really reads, but everyone signs anyway.
Exactly. But in this case, the court actually said, not so fast. They ruled that even though the client, de Klerk, technically signed the contract, some of those clauses that tried to limit Hallman's liability were just too unreasonable.
So are you saying the court basically said, we don't care if you both signed it, this clause is unfair, so we're not enforcing it?
That's essentially what happened. The court decided those clauses went against the spirit of a fair agreement, which meant they weren't made in good faith.
So even if I sign on the dotted line, good faith can still protect me from crazy, unfair terms.
It can. The court basically said you can't just hide behind a contract to avoid responsibility, especially if the terms are clearly one-sided or designed to take advantage of the other party.
Okay, that makes me feel a little better about all those contracts I've signed without reading the fine print.
But remember, it's always best to read everything carefully. This is just to show that the courts are there to ensure fairness, even if one party tries to use a contract to get away with something shady.
This is making me realize that contracts aren't just about the words themselves. It's about the intention behind them, right? Like whether those intentions align with this idea of good faith and fair dealing.
That's a great observation. It's not just about following the letter of the law. It's about the spirit of the agreement and whether both parties are acting in a way that's ethical and reasonable.
Okay, I'm really starting to see the bigger picture here. So what's our next case? I'm ready for more legal twists and turns.
All right, how about a case that's a little more relatable? Something that I think a lot of people have experienced at some point in their lives. It's Geest Nederlof from 1990, often called the secondhand car case.
Okay, a used car case. Now we're talking. I've definitely been there, done that, got the lemon. Tell me more.
So in this case, a guy named Geest buys a used car from a dealership called Nederlof. Later on, he finds some hidden problems with the car. You know, defects that weren't obvious when he bought it.
Ah, the classic used car dilemma.
Exactly. And Geest argues that the dealership should have told him about these problems before he bought the car. He takes him to court, demanding compensation for the repairs.
That sounds like a reasonable complaint. I mean, you'd expect a used car dealership to be upfront about any major issues, right?
You'd think so, wouldn't you?
Well,
But the court's ruling in this case is a bit more nuanced than that. They actually say that a seller isn't always obligated to disclose every little thing about a product.
wait, really? So you're telling me that it's okay to sell a used car with problems and not tell the buyer? That doesn't sound very good faithy to me.
Well, here's the key. It all comes down to whether the seller knew about the problem and deliberately hid it. If they did, then yeah, that's bad faith. But if they genuinely didn't know about the defect, then they wouldn't be liable.
Okay, so it's not about making the seller a mind reader. It's about preventing them from being deliberately deceptive.
Exactly. And this case reinforces a really important principle in contract law, caveat emptor.
Caveat emptor, doesn't that mean buyer beware?
It does. And it basically means that the buyer also has a responsibility to check things out before they buy, ask questions, and do their due diligence.
So it's not just about relying on the seller to be honest. You have to be an informed and proactive buyer as well.
Exactly. It's a two-way street. Sellers have to act in good faith, but buyers also have to do their part to protect themselves.
Okay, that makes sense. So good faith doesn't give buyers a free pass to be careless or naive. You still have to do your homework.
All right, it's all about balance. Speaking of understanding intentions and interpreting contracts fairly, there's another landmark case we need to discuss, Haveltex from 1981.
Okay, bring it on. I'm starting to get the sense that these Dutch and Surinamese courts really value fairness and reasonable expectations when it comes to contracts. Like, it's not just about rigidly following the rules, it's about making sure the outcome is just and equitable.
You're absolutely right. And Haveltex is a really important case because it emphasizes that contracts should be interpreted not just based on the literal words, but also on what the parties intended those words to mean.
So it's about reading between the lines, considering the context, and figuring out the spirit of the deal, not just getting bogged down in the technicalities.
Exactly. In Haveltex, there were two business partners who had a contract that included a clause about returning a piece of equipment for a refund under certain conditions.
Okay, sounds straightforward enough. What went wrong?
Well, one of the partners, Haveltex, decided to return the equipment, but he didn't give a specific reason for doing so. The other partner, Erms, refused to give him a refund, saying he didn't meet the conditions outlined in the contract.
So, classic contract dispute, a battle over the fine print.
Yep. Haveltex argued that the wording of the clause allowed him to return the equipment for any reason.
So he was sticking to the literal interpretation of the words.
Exactly. But Erms argued that there were certain implied conditions based on their shared understanding of how that clause was supposed to work.
So it was a battle of interpretations, literal versus contextual. Who won?
The court ended up siding with Erms. But what's really important about this case is why they sided with him. They established a principle that's now known as the Haveltex rule.
Okay, the Haveltex rule sounds important. What does it say?
It basically says that when you're trying to figure out what a contract means, you can't just focus on the dictionary definition of the words. You have to consider what the parties reasonably understood it to mean when they signed it.
So it's about taking into account their shared intentions, their common understanding of the deal.
Exactly. It's about looking at the bigger picture, the context of their business relationship, and what they really meant when they agreed to those terms.
Haveltex was a game changer, wasn't it?
It was. It shifted the whole focus of contract interpretation away from these rigid, literal readings towards a more holistic and contextual understanding.
Wow, these cases are fascinating. I'm seeing how each one builds upon the last, creating this legal framework that prioritizes fairness, reasonable expectations, and the spirit of agreement. It's not just about blindly following the rules, it's about making sure those rules are applied in a way that's just and equitable.
Exactly. And that's what makes this area of law so interesting to study. But wait, there's more. We've explored some of the core concepts and cases, but there's still more to uncover. We need to talk about what happens when things get even more complicated.
Oh, I'm intrigued. More complicated how?
Think about things like pre-contractual liability. Like, can you be held liable for something that happened before a contract was even signed? Or what about situations where someone tries to avoid paying their debts by transferring their assets to someone else?
Ooh, those sound like some juicy legal rabbit holes.
They are. And we'll dive into all that in the next part of our deep dive.
All right, let's jump into those legal rabbit holes you mentioned. You were talking about pre-contractual liability, right? Like what happens when things go wrong before a contract is even signed?
Exactly. It's a fascinating area of law because we often think contracts are all about what happens after you've agreed to something. But Dutch and Surinamese law recognize that even the negotiation phase can create certain obligations.
Wait, so you're telling me that I could be held liable for something that happened during negotiations, even if I didn't end up signing the contract? That seems kind of counterintuitive.
I know, right? But think about it this way. Let's say one party has invested a lot of time and resources into the negotiations, assuming the deal is going through. It wouldn't be fair for the other party to just walk away at the last minute without any consequences, especially if they were acting in bad faith.
Okay, I can see how that would be unfair. Do you have a case that illustrates this? I always find it helpful to see how these principles actually play out in real life.
There's a landmark case from 1982 that really established this principle. It's called Plas Valberg. It involved a construction company, Plas, that was in talks with the municipality of Valberg to build a swimming pool.
Oh, so like a public works project.
Exactly. And they were deep into the negotiations. Plus, had already spent a considerable amount of money preparing for the project, drawing up plans, doing all the groundwork, assuming they'd get the contract.
Sounds like they were pretty confident they had the deal in the bag.
They probably were. But then, surprise, surprise, the municipality decided to go with a different contractor.
Ouch, that's gotta hurt. So, what happened? Did Plas just have to accept defeat and eat those costs?
Not exactly. Plas was understandably upset, and they argued that the municipality acted in bad faith by breaking off the negotiations so abruptly, especially after they had already incurred all these expenses.
So the question is, can you actually be held liable just for ending negotiations? Like, where do you draw the line? Did the court side with the construction company?
The Placelberg case is so important because it actually created a three-stage framework for dealing with pre-contractual liability.
3 stages. Okay, break it down for me.
So in the first stage, which is like the very early stages of negotiation, parties are generally free to walk away without any consequences. They're just exploring possibilities, testing the waters.
Gotta no harm, no foul.
Right. But then, as those talks progress, you move into the second stage. And here there's this growing expectation of good faith and fair dealing.
So the further along you are in the process, the more you're expected to act in a way that's considerate of the other party's interests.
Exactly. At this stage, if you break off negotiations, you might be obligated to compensate the other party for the specific costs they've already incurred. Things like travel expenses, legal fees, or the cost of developing those plans we talked about.
Okay, so it's about acknowledging that their time and effort have value, even if a formal contract was never signed.
Right. And then there's the third stage, and this is where it gets really interesting. This is the point where negotiations are so advanced that a contract is basically a done deal.
Like all the details have been ironed out and everyone's just waiting to sign on the dotted line.
Exactly. At this stage, breaking off negotiations can actually be considered a breach of contract, even if nothing has been formally signed.
Wow, that's pretty powerful. It really highlights the importance of acting in good faith throughout the entire process, not just once a contract is finalized.
It does. Placevelberg was a real game changer for business practices in the Netherlands and Suriname because it made parties much more careful about how they handle negotiations. They have to realize that their actions can have legal consequences even before a contract is signed.
It's like this legal safety net to prevent parties from being strung along and then suddenly dropped. Okay, what other legal twists await us down this rabbit hole?
Let's talk about what happens when someone tries to dodge their debts. They owe someone money but try to hide their assets so it looks like they have nothing to pay with.
Ooh, sneaky. Like those scenes in movies where the con artist transfers all their money to some secret offshore account before skipping town.
That's the idea. And in legal terms, this is called fraudulent conveyance. But Dutch and Surinamese law have a specific remedy for this, the Actio Pauliana.
Actio Pauliana sounds like some kind of magical spell to catch a financial fugitive. How does it work?
It basically allows creditors to challenge those shifty asset transfers and potentially reclaim those assets to satisfy the debt.
So you can't just hide your money under the mattress and pretend you're broke.
Nope. But the key here is proving intent. The Actio Pauliana only comes into play when the debtor made those transfers with the specific intention of defrauding their creditors.
So it's not about preventing people from managing their assets. It's about preventing them from doing it in a way that's intentionally deceptive and harmful to others.
Exactly. The Actio Pauliana is another great example of how these legal systems prioritize fairness and prevent one party from taking advantage of another, even in more complex situations.
It's like they thought of everything.
Well, they try. And speaking of trying to ensure fairness, we need to touch on one more principle before we wrap up. Unjustified enrichment. It's a way of addressing those situations where someone benefits unfairly at someone else's expense, even if there's no formal contract involved.
Unjustified enrichment. So someone's getting something they don't really deserve. Can you give me a real-world example to help me understand this?
Absolutely. There's this classic case from 1959 called Quint Tay Pole. Imagine a contractor, Quint, who builds 2 shops on a piece of land. But here's the twist. He actually made the contract with the landowner's brother, who had been leasing the land.
Oh, okay, so there's already some potential for confusion and conflict there. What happened?
Well, the brother unfortunately couldn't pay Quint for the construction work. So Quint gets creative and decides to sue the landowner Tay Pole, arguing that he had benefited unfairly from the whole situation.
That's clever. I mean, Tapol ended up with 2 brand new shops on his property, even if he wasn't the one who directly hired the contractor.
Exactly. And the court agreed with Quint. They said that Tupol had indeed been unjustly enriched. But here's the really important part. They didn't create a hard and fast rule that applies in every single situation. They basically said that you have to look at each case individually and use the unjustified enrichment principle when the existing legal remedies aren't enough to ensure a fair outcome.
So it's like this flexible tool that the courts can use to address those situations where the law doesn't have a clear-cut answer, but common sense tells you something's not right.
You got it. Quinta Pol is a great example of how Dutch and Surinamese courts are willing to adapt and interpret legal principles to ensure fairness and prevent exploitation. It's not just about blindly following the rules. It's about making sure those rules are applied in a way that's just and equitable.
Wow, this has been such an eye-opening deep dive. I feel like I've gained a whole new understanding of contract law and how much emphasis these systems place on good faith, fairness, and reasonable expectations. It's not just about the black and white of the written word. It's about taking into account the context, the intentions, and the overall ethical implications of those agreements.
I'm so glad you found it insightful. It's fascinating to see how these seemingly abstract principles actually play out in real-world cases, shaping outcomes and influencing how business is done. It really makes you think about the importance of not just knowing the rules, but understanding the values that underpin those rules.
Exactly. It's not enough to just sign on the dotted line. You have to approach these agreements with a sense of responsibility, understanding that your actions have consequences even before a contract is finalized. And as we've seen, the courts are there to ensure that those consequences are fair and just. Thanks for taking us on this deep dive. It's been a real legal adventure.
Anytime. It's been a pleasure exploring these fascinating cases with you. And for our listeners, if you're ever doing business in the Netherlands or Suriname, remember